There's three attorneys there. Sharp Wadi's the one, she's the one that founded it, and many of you have probably seen her speak before. She's been around a while. I'm a little newer, a little better behind the ears, but I've done a lot. I ran into Sharp because I was doing special needs trust and Medicaid planning. And it's an area that I got really passionate about and I wanted to go into exclusively, and here I am. There's some differences that you need to know about ABLE accounts. First of all, I love ABLE accounts. I help lobby and testify about the need for such an account. I think it's great that people to open up an ABLE account don't have to come and pay an attorney. That's fantastic. Isn't it terrible that you have a non-special needs child, you can open up a 529 college savings account without bugging an attorney about it or paying an attorney. But before the ABLE account, you couldn't do the same for a child with special needs without jeopardizing their eligibility and benefits. So ABLE accounts are filling a long-needed, much-needed gap in equality for people with special needs. There are some differences that you need to be aware of, though. ABLE accounts, the age limit is a huge deal. There's legislation to try to push that 26 age limit up. The other thing is this Medicaid payback provision. Idaho's never going to let this one go. Idaho's Medicaid recovery division are almost ruthless sometimes when it comes to getting the money back that they need. And I understand both sides of the argument, but if you have an inheritance that's going to go to your child and you want it to roll over to another child after your special needs child passes, then ABLE account is not the way to do it. Also has that $14,000 a year cap. So if you try to put more in, then it could affect eligibility. We can keep going on ABLE accounts for a while, but first off, I'm going to jump back to, we're going to talk about special needs trusts just briefly. So our firm, we do kind of all wraparound, all-encompassing services of families with children with disabilities. I've got members of my family with disabilities. Shar has a daughter with disabilities that she's the guardian of, and Heather's been involved in the disability community for years now. And so one of the things that we do is we try to hit every facet. One of those is guardianship, conservatorship. I'll chat a little bit about that today if we have some time. But otherwise, we do special education litigation. We're making schools follow the IEP plan. We do 504 litigation and IDEA. We do regular estate planning and life planning. But then we do a lot of these special needs trusts and benefit planning as well, Medicaid and Social Security cases and things. So the other week, someone comes into my office and Aunt had just passed away. They have a daughter with disabilities. And Aunt loved, they had two children, one of the children with disabilities, one child that's regular functioning and going to college. And Aunt passed away unexpectedly and leaves each kid $100,000. This family has a certified family home for their daughter. They have wraparound services through Medicaid. And while Aunt had nothing but love and goodwill in her heart for this gift that she'd left for them, this has messed their lives up a little bit. Immediately, Social Security is involved in telling them their services will be terminated. Medicaid is not far behind. And this child has essentially 24-hour care that they're worried about. So what do? What do? You have over $100,000, say. So your ABLE account is automatically not an option. The answer is the special needs trust. In this case, it's called a first-party special needs trust because they didn't plan well and they didn't go around. The money went through the daughter. So the daughter inherited it, and it's her money, and she's going to have a problem if she gets it into this trust. So if you could step back, and we talk to the aunt, and say we go back 2 years, and we have a chat at the end and say, it's great that you want to provide for our daughter, but here's how we need to do it. You need to have at least language in your estate plan that says to create a trust for her so that she doesn't inherit it. Because you can't disclaim an inheritance if you have a disability. Social Security calls that a transfer of assets. Medicaid calls that a gift of assets. And if you gift assets, they say, well, you're just trying to qualify and you don't need the benefits, and you get a penalty period. For Medicaid, for every $6,500 that you give away or disclaim, That's a 1 month suspension of your benefits. So planning is really important. In this situation where we haven't planned ahead, it's a first party special needs trust. That's the answer to the question. To keep you on, to maintain your benefits and maintain the services and maintain the organization and life that you've worked so hard to set up in your certified family home, and you get it into that trust, and it saves it. When you have the one downside to waiting is that now you have to have Medicaid payback language in it. So once that money is owned or is a vested interest in the individual with special needs, then Medicaid says, I call next. I got dibs on that money. Even if your aunt wanted it to go first to the daughter and then to the son, it doesn't matter. Once it vests in the individual with special needs, Medicaid and Social Security, they know about it. And they have sharp pencils too. They look for this stuff. We had a client just last month where it was questionable. Where did this money come from? Because when grandma died in this scenario, the mom and dad had good attorneys, and they hurried up and created a supplemental needs trust, a third-party trust, and said, let's just put the money right into that trust, so it was never hers. I mean, Social Security asked for grandma's will, and they were able to tell by reading the will that that money should have gone directly to her and not into a trust. So they busted them, and then we're scrambling, right? And we have to change the trust, and all that time and money that they spent creating this other trust out the window. And not to mention your eligibility and scrambling to keep benefits for a while and fix things. So you got to do it right. You got to talk to somebody who knows how to do it. If you plan correctly, and if they would have had one provision in that will that said, not to my daughter, but to a supplemental needs trust to be created on behalf of my daughter. That's called a testamentary trust provision. That avoids the inheritance issue, and it allows them to maintain benefits. Even better would be to create the trust now, and here's why. First of all, it gives me work to do. No, I'm just joking. First of all, we don't know how long these trusts are going to be around. There are one attorney general in New Jersey. They're trying to get rid of the third-party supplemental needs trust provisions that don't require Medicaid payback. They're saying, I don't care, even if it's a third-party trust that we've never given the inheritance directly, we still want to have, the state of New Jersey still wants to be able to come in and put a lien on that money. That could change, especially in the current administration. So if you get your trust set up now, you enjoy the benefit of the current laws as they sit. If the laws get better, then you can enjoy those too. You just update your trusts. But so trusts used to not have, pre-1993, special needs trusts did not have Medicaid payback language. And so a trust that existed in 1993, pre-93, they're fine. There weren't a lot of them back then. So for the same reasons, establishing a third-party special needs trust today will keep today. If you have language in your will that says, I want a third-party special needs trust with no Medicaid payback, it doesn't matter. It doesn't matter because that trust is not in existence. And probate, unlike trusts, they're a living instrument, right? You've signed it. The law that exists as the day of that trust is the law that enforces it. Probate, you get whatever the law is at the time of death. So if you want to create that, if you have instructions to create at the time of death, and 20 years down the road, grandma dies, and the law is different, then you're stuck with the new law. Any questions? I'll keep going if you don't stop me.
Just I don't totally understand trust. If you were to establish a trust right now so that you can be under whatever Medicaid language is the trust something that you can continue to contribute to, or is it set? Okay.
So her question is, once you establish a trust, how does it work? Can you keep putting money in it? Yes. A trust is nothing more than a legal fiction. Where if I want, this is a great paperclip right here, but if I wasn't able, because of some silly law, to own this paperclip, I could give it to my buddy here, And he has now the rights to own and use this paperclip on my behalf. It's my paperclip. I just don't own it. But whenever I want it, I say, hey, Raymond, can I see that paperclip? He's my trustee. And I can give him more paperclips and whatever else I wanted to put in that trust. And if Social Security said, or Medicaid said, this guy can't own paperclips, I would be fine. But the second I otherwise take ownership of the paperclip, and then I'm in trouble. So it's just legal fiction. And you open up a bank account at any bank is more than happy to take your money and open up a bank account. And it's whether or not they'll help you be trustees where we fight with the banks. But any bank does it. A trustee is a good question is, what about a trustee? Trustee training is one thing that we're constantly doing at our firm because these trusts have special rules. These trusts have two of the big ones. I mean, I could talk for days about it, but two of the big ones are who can these trusts be used for? Okay, these trusts have what's called sole benefit clauses. So if the money is used for anybody except for the special needs beneficiary, that's a problem. Medicaid comes after you. Social Security comes after you. They want back pay. They want cessation of benefits. And so you have to have a trustee who understands the rules and has the training. And that's one of the things we provide, is this training. The other big rule is if it's a first-party trust, where it's the person's money, then this is where you don't have to worry about it as much. But it has to have their money, and you can put money in. Anyone can put money in a first-party trust. Grandma can give money to it, grandpa, whoever else, mom, dad. But in a third-party trust, this trust that doesn't have the Medicaid payback language, the trust that was created before the money was gifted to the child, this trust can never have that child's assets in it. If you cross that barrier, it changes the trust. And Medicaid says, you hid their assets in there. Anything that's their asset, we have claim to. Now the whole trust is tainted, kind of the ink in the water thing. And so another thing we do a lot is we work with trustees and families to maintain the sanctity of these trusts and not mess them up. Because if you mess it up, it's out the window. Your planning that you spent so much time and effort to get done. Especially most of my families, I mean, when we're thinking about how we want our state to be divided, or state, it's never going to be, if you have two kids, one with special needs, it's usually not 50-50. They're going to need a lot more resources than our child that can provide for themselves can. And so usually it's more like 80-20 or 60-40, the division of the estate. And so it's also the parents' wish that when the child with special needs passes away, that we want it to go to other children. And if you mess up the trust, then Medicaid comes in and they put their foot down. So it's really important to get this done correctly. Any other questions? Otherwise, I'll stop droning.
So we've already had a trust done with a lawyer. How do I make sure I have this Medicaid language? And
Bring it by for a free consult.
okay.
We this month alone, then these are just people that have come because Social Security in the last year has really upped their game. They hired a whole new department in Seattle that reviews these trusts, and if they find the problem with the trust language, they give you the letter saying, tough, this is considered, and you're over the resource limit. And so in the last month alone, I've probably had half a dozen of these cases come in from great attorneys. But this is such a small niche area, these trusts are so intricate and detailed, that here's the biggest problem. The biggest problem I see is, and it's silly, it's such a ticky-tacky little procedural issue, but the trust says, we want to pay back any money left upon the death of the individual will be paid back to the state of Idaho Medicaid up to the amount of Medicaid services provided. Anybody see anything wrong with that? Sounds like what's supposed to happen. Well, the federal law doesn't say state of Idaho. Federal law says any state. And so the Social Security Administration will take your trust, and most of the attorneys in Idaho are drafting it to say, state of Idaho, not any state. And they don't even tell you why, they just say, your benefits are going. And then our families are spending a good few weeks scrambling, trying to get more information from Social Security, who says, well, I don't know who made the decision. I just know that you're in trouble. And then they come out, and then we find it, and we we work hard to get it fixed quick. So bring it by, we'll take a look for free, and if it's great, then thumbs up. If not, we'll warn you ahead of time. Any other questions?
So how can the Able account and your trust accounts kind of work together?
Ooh, this is a good question. This is such you see how excited I get? This is such the Able accounts, one of the reasons they're so awesome is because, and I don't have time to talk about this in detail, but your Able account and your special needs trust, they don't work the same. The Able accounts, as you heard, they're only for qualified disability expenses. So there are some things that those accounts, by definition, are not supposed to pay for. Special needs trusts are not supposed to pay for food or shelter. Able can. So when we have a client, and just barely had a client who all of a sudden we have a housing issue and we need extra rent money, and he has a special needs trust that can't pay for that. Well, guess what? Just take a little bit of money, shift it over to the Able. Able pays for it. And it's this, like I said, it's new. So there's the first thing I tell people is it's a risk. In this case, we didn't have any other options to keep this guy's rent. So, but on a national level, the discussions and the research that we've seen is that no one's freaking out about this. Medicaid and Social Security are not freaking out about this. Idaho Medicaid is another question. We'll see. So that's not legal advice to do for anybody in this room until I give a huge disclaimer and we have a big long talk about whether it's necessary. But there are great things like that are going on.
If you have things set up, you
Yes.
can just draw from both of those places.
They can work together. Exactly. Any other questions? Yeah.
Are there any advantages to doing trust in state versus out of state?
So if you're in Idaho, and Medicaid, Idaho Medicaid is going to be the person, the entity that's going to be reviewing it, then it's better to have them review it here. They're really strict. I've never had a trust that was approved by an Idaho after Idaho Medicaid review be found no good from another state, but I've seen the opposite happen. They're pretty serious here in Idaho. They've got their deputy attorney generals on the case. So if you go to another state where they're less, and you created another state where there's no review process and they're a little less strict and stringent about this, and then you come to Idaho, then you may have an interruption event. New Jersey is really strict about theirs, for example. I mean, they've got a checklist of like 40 things that they look for in these trusts. Idaho just kind of swings from the hip. And, so it depends on who's reviewing it, but we were really conservative about these. We drafted them to hit all the areas. So, yes, in the back.
So what do we need to do to start a trust now? I mean, I have no idea. Like,
Come and talk to me, because there's not enough time to explain. You may not need one, but maybe an Able account will fulfill all your needs, which would be great. Because trusts you have to go talk to these attorneys, and they're so annoying. They just don't shut up. And then it just takes time and money, and they're not the answer to everyone's questions. Able accounts are a great answer for a lot of questions now. Yeah. I'm getting the evil eye. Yeah. I'm gonna go.
This is really important information.
Yeah. I'll leave a stack of cards and some things. If you guys have questions, feel free to reach out. We give free consult. We'll talk to anybody for however long it takes. So, thanks.
Thank you.